before the court are good. Mr. Lakin?
What's that?
We're good as far as the jury instructions go?
Yes, I know it should be.
All right, very good. All right, ladies and gentlemen, I am going to give you the jury instructions applicable to this case. It's going to take me a while to go through these. When I am completed, however, I am going to discharge you for the day and ask you to be back tomorrow morning. Any problem with being back here at 8:30 tomorrow morning? All right, and I'm going to bring you back here at 8:30 tomorrow morning. We're going to have closing arguments of the respective parties, and then I will be sending... Yes, ma'am. If you can you? And I know you have to drop off one of the children or something. Just get here. When you get here, then we'll convene as soon as you're here, okay? Don't get a speeding ticket. All right? And we'll convene tomorrow morning. When you get here, we'll hear the closing arguments of the parties, and I'll be sending you out for your deliberations. As Rob is going to tell you later, bring a lunch, or we're going to buy you some lunch, and he'll discuss that with you later. But you will be here for the remainder of the day for your deliberations tomorrow. All right? Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Frankie Bybee, the defendant in this case, has been accused of the crimes of Count 1, attempted murder in the first degree; Count 2, kidnapping; Count 3, burglary of a dwelling with battery; Count 4, exploitation of an elderly person; Count 5, fraudulent use of personal identification information. And that would be as to December 10th, 2016. And I will tell you, you will have a copy of these jury instructions with you, so you don't need to take any notes. Count 6, fraudulent use of personal identification information related to December 11th, 2016. Count 7, fraudulent use of personal identification information related to December 14th, 2016. Count 8, fraudulent use of personal identification information related to December 14th, 2016. Count 9, fraudulent use of personal identification information related to December 15th, 2016. Count 10, fraudulent use of personal identification information related to December 16th, 2016. Count 11, fraudulent use of personal identification information related to December 17th, 2016. Count 12, fraudulent use of personal identification information related to December 18th, 2016. Count 13, fraudulent use of personal identification information related to December 19th, 2016. And count 14, fraudulent use of personal identification information related to December 28th, 2016. Count 15, offense against users of computer systems, computer networks, and electronic devices related to allegations on December 22nd, 2016. Count 16, offenses against users of computers, computer systems, computer networks, and electronic devices related to allegations December 28th, 2016. Count 17, offenses against users of computers, computer systems, computer networks, and electronic devices related to allegations December 28th, 2016. And lastly, count 18, fraudulent use of personal identification information related to December 13th, 2016. In this case, the defendant is charged with the crime of attempted murder in the first degree. Attempted murder in the first degree includes the lesser crimes of attempted murder in the second degree and attempted manslaughter by act, all of which are unlawful. An attempted murder that is excusable or was committed by the justifiable use of deadly force is lawful. If you find that there was an attempted homicide of Marcia Soul by Frankie Bybee, you will then consider the circumstances surrounding the attempted homicide in deciding whether it was attempted first-degree murder or attempted second-degree murder, or attempted manslaughter by act, or whether the attempted homicide was excusable or resulted from justifiable use of deadly force. Justifiable attempted homicide. An attempted homicide is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the attempted homicide. Excusable attempted homicide. An attempted homicide is excusable and therefore lawful under any one of the following three circumstances. First, when the attempted homicide is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or two, when the attempted homicide occurs by accident and misfortune in the heat of passion, upon any sudden and sufficient provocation. Or three, when the attempted homicide is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the attempted killing is not done in a cruel or unusual manner. A dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before Frankie Bybee may be found guilty of attempted first-degree murder. To prove the crime of attempted first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. Frankie Bybee did some act intended to cause the death of Marcia Soul that went beyond just thinking or talking about it. 2, Frankie Bybee acted with a premeditated design to kill Marcia Soul. 3, the act would have resulted in the death of Marcia Soul except that someone prevented Frankie Bybee from killing Marcia Soul, or he failed to do so. A premeditated design to kill means that there was a conscious design to kill. The decision must be present in the mind at the time the act was committed. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the act. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the act was committed. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the attempted killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the attempted killing. It is not an attempt to commit first-degree premeditated murder if the defendant abandoned the attempt to commit the offense or otherwise prevented its commission under circumstances indicating a complete and voluntary renunciation of his criminal purpose. Count 2, kidnapping. To prove the crime of kidnapping, the state must prove the following three elements beyond a reasonable doubt. First, Frankie Bybee secretly confined Marcia Soul against her will. Element 2, Frankie Bybee had no lawful authority to do so. And 3, Frankie Bybee acted with intent to commit or facilitate the commission of exploitation of an elderly person and or fraudulent use of personal identification information. In order to be a kidnapping, the confinement, A, must not be slight, inconsequential, or merely incidental to the exploitation of an elderly person and or fraudulent use of personal identification information. B, must not be of the kind inherent in the nature of the exploitation of an elderly person and or fraudulent use of personal identification information. And C, must have some significance independent of the exploitation of an elderly person and or fraudulent use of personal identification information, in that it makes the exploitation of an elderly person and or fraudulent use of personal identification information substantially easier of commission or substantially lessens the risk of detention. Secretly means the defendant intended to isolate or insulate Marcia Soul from meaningful contact or meaningful communication from the public. Exploitation of an elderly person means knowingly obtaining or using or endeavoring to obtain or use an elderly person's funds, assets, or property with the intent to temporarily or permanently deprive the elderly person of the use, benefit, or possession of the funds, assets, or property, or to benefit someone other than the elderly person by a person who stands in a position of trust and confidence with the elderly person. Endeavor means to attempt or try. Obtains or uses means any manner of taking or exercising control over property, or B, making any use, disposition, or transfer of property. Position of trust and confidence with respect to an elderly person means the position of a person who, A, is a parent, spouse, adult child, or other relative by blood or marriage of the elderly person. B, is a joint tenant or tenant in common with the elderly person. C, has a legal or fiduciary relationship with the elderly person, including but not limited to a court-appointed or voluntary guardian, trustee, attorney, or conservator. D, is a caretaker of the elderly person. Or E, is any other person who has been entrusted with or has assumed responsibility for the use or management of the elderly person's funds and or property. Caretaker means a person who has been entrusted with or has assumed responsibility for the care or the property of an elderly person. Caregiver includes, but not limited to, relatives, court-appointed or voluntary guardians, adult household members, neighbors, healthcare providers, and employees and volunteers of facilities. Property means anything of value and includes A, real property, including things growing on, affixed to, and found in the land. B, tangible or intangible property, including rights, privileges, interests, and claims. C, services. In the case of a written instrument that does not have a readily ascertainable market value, such as a check, draft, or promissory note, the value is the amount due or collectible. Willfully means intentionally and purposefully. Fraudulently means purposefully and intentionally suppressing the truth or pretending a deception or both. Authorization means empowerment, permission, or competence to act. Personal identification information means any name or number that may be used alone or in conjunction with any other information to identify a specific individual, including any name, postal or electronic mail address, telephone number, social security number, date of birth, mother's maiden name, official state or United States issued driver's license or identification number, alien registration number, government passport number, employer or taxpayer's identification number, Medicaid or food stamp account number, bank account number, credit or debit card number or personal identification number or code assigned to the holder of a debit card by the issuer or permit authorized use of such card, unique biometric data such as a fingerprint, voice print, retina or iris image, or any unique physical representation, unique electronic identification number, address, or routing code, medical record, telecommunication identification information or access device, or any or other number or information that can be used to assess a person's financial resources. That, I need to wet my whistle. Count 3, burglary of a dwelling with battery. To prove the crime of burglary, the state must prove the following two elements beyond a reasonable doubt. 1, Frankie Bybee entered a structure owned by or in the possession of Marcia Soul. 2, at the time of entering the structure, Frankie Bybee had the intent to commit homicide or battery in that structure. 3, Frankie Bybee was not invited to enter the structure, or he remained in the structure after permission to remain therein had been withdrawn with the intent to commit an offense therein. You may infer that Frankie Bybee had the intent to commit a crime inside a structure if the entering of the structure was done stealthily and without the consent of the owner or occupant. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct or positive proof. It may be established by circumstantial evidence like any other fact in a case. Even though an unlawful entering is proved, if the evidence does not establish that it was done with the intent to commit battery and or homicide, the defendant must be found not guilty of burglary. Structure means any building of any kind, either temporary or permanent, that has a roof over it and the enclosed space of ground and outbuildings immediately surrounding that structure. If you find Frankie Bybee guilty of burglary, you must also determine if the state has proved beyond a reasonable doubt whether, in the course of committing the burglary, Frankie Bybee battered any person. A battery is an intentional or an actual or intentional touching or striking of another person against that person's will, or the intentional causing of bodily harm to another person. If you find Frankie Bybee guilty of burglary, you must also determine if the state has proved beyond a reasonable doubt whether the structure entered was a dwelling. Dwelling means a building of any kind, whether such building is temporary or permanent, mobile or immobile, which has a roof over it and is designed to be occupied by people lodging therein at night. Together with the enclosed space of ground and outbuildings immediately surrounding it. For purposes of burglary, a dwelling includes an attached porch or attached garage. If you find Frankie Bybee guilty of burglary, you must also determine if the state has proved beyond a reasonable doubt whether, in the course of committing the burglary, there was another human being in the structure at the time he entered the structure. Count 4, exploitation of an elderly person. To prove the crime of exploitation of an elderly person, the state must prove the following 4 elements beyond a reasonable doubt. 1, Marcia Soul was an elderly person. 2, Frankie Bybee knowingly obtained or used and or endeavored to obtain or use Marcia Soul's funds. 3, Frankie Bybee did so with the intent to temporarily or permanently deprive Marcia Soul of the use, benefit, or possession of her funds. 4, at the time, Frankie Bybee stood in a position of trust and confidence with Marcia Soul. If you find Frankie Bybee guilty of exploitation of an elderly person, you must then determine whether the state has proved or proven beyond a reasonable doubt that A, the funds involved in the exploitation of the elderly person are valued at $50,000 or more. B, the funds involved in the exploitation of an elderly person are valued at $10,000 or more, but less than $50,000. Or C, the funds involved in the exploitation of an elderly person are valued at less than $10,000. Much to my chagrin, elderly person means a person 60 years of age or older who is suffering from the infirmities of aging as manifested by advanced age or organic brain disease or other physical, mental, or emotional dysfunctioning, to the extent that the ability of the person to provide adequately for the person's own care or protection is impaired. Endeavor means to attempt or try. Obtains or uses means any manner of A, taking or exercising control over property, or B, making any use, disposition, or transfer of property. Position of trust and confidence with respect to an elderly person means the position of a person who A, is a parent, spouse, adult child, or other relative by blood or marriage of an elderly person. B, is a joint tenant or tenant in common with the elderly person. C, has a legal or fiduciary relationship with the elderly person, including but not limited to a court-appointed or voluntary guardian, trustee, attorney, or conservator. D, is a caregiver of the elderly person. Or E, is any other person who has been entrusted with or has assumed responsibility for the use or management of the elderly person's funds and or property. Caregiver means a person who has been entrusted with or has assumed responsibility for the care of or the property of an elderly person. Caregiver includes, but is not limited to, relatives, court-appointed or voluntary guardians, adult household members, neighbors, healthcare providers, and employees and volunteers of facilities. Property means anything of value and includes A, real property, including things growing on it, affixed to it, or found in the land. B, tangible or intangible personal property, including rights, privileges, interests, and claims. Or C, services. In the case of a written instrument that does not have a readily ascertainable market value, such as a check, draft, or promissory note, the value is the amount due or collectible. Count 5, fraudulent use of personal identification information. And this relates to December 10th, 2016, Walgreens ATM, 1947 Fruitville Road, Sarasota. To prove the crime of fraudulent use of personal identification information, the state must prove the following 2 elements beyond a reasonable doubt. 1, Frankie Bybee willfully and without authorization fraudulently used personal identification information concerning Marcia Soul. 2, he did so without first obtaining the consent of Marcia Soul. Willfully means intentionally and purposefully. Fraudulently means purposefully or intentionally suppressing the truth or perpetrating a deception or both. Authorization means empowerment, permission, or competence to act. And personal identification information means any name or number that may be used alone or in conjunction with any other information to identify a specific individual, including any name, postal or electronic mail address, telephone number, social security number, date of birth, mother's maiden name, official state or United States driver's license or identification number, alien registration number, government passport number, employer or taxpayer's identification number, Medicaid or food stamp account number, bank account number, credit or debit card number or personal identification number or code assigned to the holder of a debit card by the insurer to permit authorization or authorized use of such a card. Unique biometric data such as fingerprint, voice print, retina or iris image, or other unique physical representation, unique electronic identification number, address or routing number, medical record, telecommunication identification information or access device, or other number or information that can be used to access a person's financial resources. Count 6, fraudulent use of personal identification information relating to allegations of December 11th, 2016, Publix ATM at 4240 53rd Avenue, East Bradenton. To prove the crime of fraudulent use of personal identification information, the state must prove the following two elements beyond a reasonable doubt. Frankie Bybee willfully and without authorization fraudulently used personal identification information concerning Marcia Soul. He did so without first obtaining the consent of Marcia Soul. Willfully, and its definition has been previously explained to you. Fraudulently has been given to you and previously explained to you. Authorization has been previously given and explained to you, as has personal identification information. Defense have any objection to my doing the reference to previously given jury instructions? Thank you, sir. Count 7, fraudulent use of personal identification information related to December 14th, 2016, Walgreens ATM, 3601 Bee Ridge Road, Sarasota. To prove the crime of fraudulent use of personal identification, the state must prove the following two elements beyond a reasonable doubt. 1, Frankie Bybee willfully and without authorization fraudulently used personal identification information concerning Marcia Soul. And 2, he did so without first obtaining the consent of Marcia Soul. Again, willfully has been defined and given to you previously. Fraudulently has been given and explained to you previously, as has authorization and the definition of personal identification information. Count 8, fraudulent use of personal identification information related to December 14th, 2016, the Sunoco station at 1012 North Tamiami Trail, Sarasota. To prove the crime of fraudulent use of personal identification information, the state must prove the following two elements beyond a reasonable doubt. First, Frankie Bybee willfully and without authorization fraudulently used personal identification information concerning Marcia Soul. Second, he did so without first obtaining the consent of Marcia Soul. Again, the definitions of willfully, fraudulently, authorization, and personal identification information have previously been explained and given to you. Count 9, fraudulent use of personal identification information related to December 15th, 2016, CVS ATM, located at 5310 45th Street, East Bradenton. To prove the crime of fraudulent use of personal identification, the state must prove the following two elements beyond a reasonable doubt. First, Frankie Bybee willfully and without authorization fraudulently used personal identification concerning Marcia Soul. 2, he did so without first obtaining the consent of Marcia Soul. Willfully, fraudulently, authorization, and personal identification information have previously been given to you and explained to you. Count 10, fraudulent use of personal identification information related to December 16th, 2016, 7-Eleven ATM at 1721 North, I guess that's Honore, Honore Ave in Sarasota. To prove the crime of fraudulent use of personal information, the state must prove the following two elements beyond a reasonable doubt. 1. Frankie Bybee willfully and without authorization fraudulently used personal identification information concerning Marcia Soul. And 2. He did so without first obtaining the consent of Marcia Soul, again willfully, fraudulently, authorization, and personal information, identification information have been explained and given to you previously. Count 11, fraudulent use of personal identification information related to December 17th, 2016, Wells Fargo ATM, 3625 Bee Ridge Road, Sarasota. To prove the crime of fraudulent use of personal identification information, the state must prove the following two elements beyond a reasonable doubt. First, Frankie Bybee willfully and without authorization fraudulently used personal identification information concerning Marcia Soul. And 2, he did so without first obtaining the consent of Marcia Soul. The definitions for willfully, fraudulently, authorization, and personal identification information have previously been explained to you. Count 12, fraudulent use of personal identification information related to December 18th, 2016, Wells Fargo ATM, located at 3625 Bee Ridge Road, Sarasota. To prove the crime of fraudulent use of personal identification information, the state must prove the following two elements beyond a reasonable doubt. First, Frankie Bybee willfully and without authorization fraudulently used personal identification information concerning Marcia Soul. And 2, he did so without first obtaining the consent of Marcia Soul. Again, willfully, fraudulently, authorization, and personal identification information have been given and explained to you. Count 13, fraudulent use of personal identification information pertaining to December 19th, 2016, fraudulent use of Marcia Soul's PayPal/Citibank credit card. To prove the crime of fraudulent use of personal identification information, the state must prove the following two elements beyond a reasonable doubt. To prove the crime of fraudulent use of personal identification information, the state must prove the following two elements beyond a reasonable doubt. First, Frankie Bybee willfully and without authorization fraudulently used personal identification information concerning Marcia Soul. He did so without first obtaining the consent of Marcia Soul. Again, the definitions of willfully, fraudulently, authorization, and personal identification information are set forth and have previously been explained to you. Counts 14, fraudulent use of personal identification information related to allegations of December 28th, 2016, used Marcia Soul's password to access her AOL account. To prove the crime of fraudulent use of personal identification information, the state must prove the following two elements beyond a reasonable doubt. First, Frankie Bybee willfully and without authorization fraudulently used personal identification information concerning Marcia Soul. He did so without first obtaining the consent of Marcia Soul, element 2. Again, willfully, fraudulently, authorization, personal identification information, and their definitions have been previously given to you. Count 15, offense against computer users. December 22nd, 2016, fraudulent email to Philomena Herrera. To prove the crime of offense against computer users, the state must prove the following two elements beyond a reasonable doubt. First, Frankie Bybee willfully, knowingly, and without authorization accessed any computer. And 2, Frankie Bybee did so for the purpose of devising or executing any scheme or artifice to defraud or obtain property. Access means to approach, instruct, communicate with, store data in, retrieve data from, or otherwise make use of any resources of a computer, computer system, or computer network. Computer means an internally programmed automatic device that platforms data processing. Computer network means any system that provides communications between one or more computer systems and its input or output devices, including but not limited to display terminals and printers that are connected by telecommunication facilities. Computer program or computer software means a set of instructions or statements and related data which, when executed in actual or modified form, cause a computer, computer system, or computer network to perform specific functions. Computer services include, but are not limited to, computer time, data processing or storage functions, or other uses of a computer, computer system, or computer network. Computer system means a device or collection of devices, including support devices, one or more of which contain computer programs, electronic instructions, or input data and output data, and which perform functions including but not limited to logic, arithmetic, data storage, retrieval, communication, or control. The term does not include calculators that are not programmable and that are not capable of being used in conjunction with external files. Data means a representation of information, knowledge, facts, concepts, computer software, computer programs, or instructions. Data may be in any form in storage media or stored in the memory of a computer or in transit or presented on a display device. Knowingly means with full knowledge and intentionally. Property means anything of value as defined in Florida Statute 815.03 subsection 11 and includes but is not limited to financial instruments, information, including electronically produced data and computer software and programs in either machine readable or human readable form, and any other tangible or intangible item of value. Florida Statute 815.03 subsection 11 is defined as follows. Intellectual property means data including programs. Willfully means intentionally and purposefully. Count 16, offense against computer users. The allegation of December 28, 2016, fraudulent email to Dr. Lerner. To prove the crime of offense against computer users, the state must prove the following two elements beyond a reasonable doubt. One, Frankie Bybee willfully, knowingly, and without authorization accessed any computer. And two, Frankie Bybee did so for the purpose of devising or executing any scheme or artifice to defraud or obtain property. The definitions of access, computer, computer network, computer program or computer software, computer services, computer system, data, knowingly, property, and willfully have previously been given to you. Count 17, offense against computer users related to December 28, 2016, fraudulent email to Mary Ann Dumbrow. To prove the crime of offense against computer users, the state must prove the following two elements beyond a reasonable doubt. First, Frankie Bybee willfully, knowingly, and without authorization accessed any computer. 2, Frankie Bybee did so for the purpose of devising or executing any scheme or artifice to defraud or obtain property. And again, the definitions of access: computer, computer network, computer program or computer software, computer services, computer system, data, knowingly and properly and willfully have been given to you. Count 18, fraudulent use of personal identification information related to December 13th, 2016. Defendant changed Marcia Soul's PayPal security questions and passwords. If, sorry, to prove the crime of fraudulent use of personal identification information, the state must prove the following 2 elements beyond a reasonable doubt. 1, Frankie Bybee willfully and without authorization fraudulently used personal identification information concerning Marcia Soul. He did so. 2, he did so without first obtaining the consent of Marcia Soul. Once again, the definitions of willfully, fraudulently, authorization, and personal identification information are set forth, but have been previously explained to you. Where there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes with which he is accused, there may be evidence that he committed other acts that would constitute lesser included crimes. Therefore, if you decide that the main accusations have not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crimes. The lesser included crimes indicated in the definition of attempted murder in the first degree are attempted murder in the second degree and attempted manslaughter by act. The lesser crime indicated in the definition of kidnapping is false imprisonment. The lesser crime indicated in the definition of burglary with a battery is burglary. The lesser crimes indicated in the definition of exploitation of an elderly are grand theft, the value of the property taken being $20,000 or more, but less than $100,000. Grand theft, the value of the property taken was $10,000 or more, but less than $20,000. Grand theft, the value of the property taken was $5,000 or more, but less than $10,000. And grand theft, value of the property taken was $300 or more, but less than $5,000. There is no lesser crime indicated in the definition of fraudulent use of personal identification information. The lesser crime indicated in the definition of offenses against computer users to fraud or obtain property is offenses against computer users. The definition of attempted second-degree murder is as follows. To prove the crimes of attempted second-degree murder, the state must prove the following 2 elements beyond a reasonable doubt. First, Frankie Bybee intentionally committed an act which would have resulted in the death of Marcia Soul, except that someone prevented Frankie Bybee from killing Marcia Soul, or he failed to do so. 2, the act was imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict the defendant of attempted second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. It is not an attempt to commit second-degree murder if the defendant abandoned the attempt to commit the offense or otherwise prevented its commission under circumstances indicating a complete and voluntary renunciation of his criminal purpose. The definition of attempted manslaughter by act is as follows. To prove the crime of attempted manslaughter by act, the state must prove the following element beyond a reasonable doubt. 1. Frankie Bybee intentionally committed an act which would have resulted in the death of Marcia Soul, except that someone prevented Frankie Bybee from killing Marcia Soul, or he failed to do so. However, the defendant cannot be guilty of attempted manslaughter by act by committing a merely negligent act. Each of us has a duty to act reasonably and use ordinary care towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. It is not an attempt to commit manslaughter if the defendant abandoned the attempt to commit the offense or otherwise prevented its commission under circumstances indicating a complete and voluntary renunciation of his criminal purpose. As it's related to kidnapping, the definition of false imprisonment is as follows. To prove the crime of false imprisonment, the state must prove the following two elements beyond a reasonable doubt. 1. Frankie Bybee secretly confined Marcia Soul against her will. 2. Frankie Bybee had no lawful authority to do so. Secretly means the defendant intended to isolate or insulate Marcia Soul from meaningful contact or meaningful communication with the public. Burglary. To prove the crime of burglary, the state must prove the following two elements beyond a reasonable doubt. Frankie Bybee, 1. Frankie Bybee entered a structure owned by or in the possession of Marcia Soul. 2. At the time of entering the structure, Frankie Bybee had the intent to commit homicide and or battery in a structure. 3. Frankie Bybee was not invited to enter the structure. You may infer that Frankie Bybee had the intent to commit a crime inside a structure if the entering of the structure was done stealthily and without the consent of the owner or occupant. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct or positive proof. It may be established by circumstantial evidence like any other fact in a case. Even though an unlawful entering is proved, if the evidence does not establish that it was done with the intent to commit battery and or homicide, the defendant must be found not guilty of burglary. Structure means any building of any kind, either temporary or permanent, that has a roof over it and the enclosed space or ground and outbuildings immediately surrounding that structure. If you find Frankie Bybee guilty of burglary, you must also determine if the state has proved beyond a reasonable doubt that the structure entered was a dwelling. Once again, a dwelling means a building of any kind, whether such building is temporary or permanent, mobile or immobile, which has a roof over it, and is designed to be occupied by people lodging therein at night, together with the enclosed space of ground and outbuildings immediately surrounding it. For the purpose of burglary, a dwelling includes an attached porch or attached garage. If you find Frankie Bybee guilty of burglary, you must also determine if the state has proved beyond a reasonable doubt whether, in the course of committing that burglary, there was another human being in the structure at the time he entered the structure. Definition of theft is as follows. To prove the crime of theft, the state must prove the following two elements beyond a reasonable doubt. First, Frankie Bybee knowingly and unlawfully obtained or used or endeavored to obtain or use the property of Marcia Soul. Second, he did so with intent to either temporarily or permanently appropriate the property of Marcia Soul to his own use or to the use of any person not entitled to it. If you find the defendant guilty of theft, you must also determine if the state has proved beyond a reasonable doubt whether A, the value of the property taken was $20,000 or more but less than $100,000. B, the value of the property taken was $10,000 but less than $20,000. C, the value of the property taken was $5,000 but less than $10,000. Or D, the value of the property taken was $300 or more but less than $5,000. Proof of possession of recently stolen property, unless satisfactorily explained, gives rise to an inference that the person in possession of the stolen property knew or should have known that the property had been stolen. Obtains or uses means any manner of taking or exercising control over property. B, making any unauthorized use, disposition, or transfer of property. C, obtaining property by fraud, willful misrepresentation of an act, a future act, or false promise. Or D, conduct previously known as stealing, larceny, purloining, abstracting, embezzlement, misapplication, misappropriation, conversion, or obtaining money or property by false pretenses, fraud, deception, or other conduct similar in nature. Endeavor means to attempt or try. Again, property means anything of value, including tangible or intangible property, including rights, privileges, interests, and claims. Value means the market value of the property at the time and place of the offense, or if that value cannot be satisfactorily ascertained, the cost of replacement of the property within a reasonable time after the offense. If the exact value of the property cannot be ascertained, you should attempt to determine a minimum value. If you cannot determine a minimum value, you must find the value is less than $100. In the case of a written instrument that does not have a readily ascertainable market value, such as a check, draft, or promissory note, the value is the amount due or collectible. Accounts of value of separate properties involved in thefts committed pursuant to one scheme or course of conduct, whether the thefts are from the same person or several persons, may be added together to determine the total value of the theft. Offense against computer users is defined as follows. To prove the offense against computer users, the state must prove the following element beyond a reasonable doubt. 1, Frankie Bybee willfully, knowingly, and without authorization accessed any computer. Again, the definitions of access: computer, computer network, computer program or computer software, computer services, computer system, data, knowingly, property, willfully, have been set forth in this jury instruction, have been previously defined for you. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means that you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment and information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, then you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? And 6, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusions about the witnesses. A juror may believe or disbelieve all or any part of the evidence or testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the stand to give testimony in his case. Statements claimed to have been made by the defendant outside of court have been placed before you. Such statements should always be considered with caution and be weighed with great care to make certain they were freely and voluntarily made. Therefore, You must determine from the evidence that the defendant's alleged statements were knowingly, voluntarily, and freely made. In this determination, you should consider the total circumstances, including but not limited to, 1, whether when the defendant made his statement, he had been threatened in order to get him to make the statement, and 2, whether anyone had promised him anything in order to get him to make the statement. If you conclude the defendant's out-of-court statements were not freely and voluntarily made, you should disregard them. Rules for deliberation. There are certain general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. First, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending on you or upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits in evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry with anyone. 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. And 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I prefer one verdict over another. A separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. You may find the defendant guilty as charged in the information, or guilty of any lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. Only one verdict may be returned to the crime charged. This verdict must be unanimous. That is, all of you must agree to the same verdict. The verdict must be in writing, and for your convenience, the necessary form of verdict has been prepared for you. We have not settled on a final draft of the verdict form, is that correct?
Yes, sir. That's
all right. I will just explain to you folks, the verdict form will look something like this. We need to change a few words, but the verdict form will look like this. And the verdict form lays out each count, the crime charged in each count, and gives you the determination as to your findings. So that will be sent back with the jury instructions tomorrow. Does the defense have any objections to the reading of the jury instructions as given?
No, Your Honor.
State?
No, Your Honor.
All right. Any other matters we need to discuss in the presence of the jury at this time?
No, Your Honor.
All right.
No, sir.
Ladies and gentlemen, I am going to discharge you for the day. We will reconvene as close to 8:30 as we can, but again, I want to get in speedy for this tomorrow. Please be seated, everyone. And the record will reflect that the jury has exited the courtroom at this time. Ladies and gentlemen, I will be submitting the case to the jury as the final jury instruction after we have concluded our closing arguments tomorrow. It was my understanding both sides was requesting 2 hours for closings tomorrow. Is that still the case?
Yes.
All right.
Yes, Your Honor.
All right.
Can I address one question of the court? You had mentioned giving the jurors copies of instructions.
Right.
With the court, and my concern is this, if we just give them the elements, we're highlighting and emphasizing one jury instruction from the others. My request would be, if you're going to give the jurors instructions, give them the full package. And because, you know, the reasonable doubt is just as important as the elements. And I'm not trying to circumvent the court. I just...
No, I understand. I understand your position, Mr. Kapir. It's not an unreasonable, and many courts require that a separate set of jury instructions be prepared for each juror anyway. Depending on the severity of the case, I either agree to that or I don't agree with that.
Yes, sir.
Given the number of elements, the severity of the case, the possible implications, why don't we do that?
Yes.
Why don't we provide 6 copies for the jury room tomorrow? Full complement of jury instructions for each juror.
I'll just take out the verdict form.
I just take out the verdict form. When we meet tomorrow morning, we'll have a couple of minutes. Why don't we all try to be here at 8:30? We'll take a look at that verdict form, make sure that's approved, and we'll conduct closings as soon as the jury is ready. We should be able to get this to them sometime around lunchtime tomorrow.
Okay, are we going to go over the verdict form now?
If you have it, I'm happy to do it now.
I do have it.
Right, have you?
Completed and it's in the packet.
We're prepared.
Okay, as long as we're all prepared, I have no problem doing that at all.
I think it's easier this way. And then
Sure, I didn't know if you had already identified some things you needed to change.
I did, and I fixed the interrogatories. And if there are any changes, at least I can make them overnight. So we don't have to delay in the morning.
All right, then let's take a look at the verdict form at this time. All right, verdict form for the record reads as follows. In the Circuit Court of the 12th Judicial Circuit in and for Sarasota County, Florida, State of Florida versus Frankie Bybee, defendant. Case number 2017 CF 001018, verdict. Count 1 reads as follows. We, the jury, find as follows as to count 1. In parentheses, check one box only. A, defendant is guilty of attempted murder in the first degree as charged. B, the defendant is guilty of attempted murder in the second degree, a lesser included offense. C, the defendant is guilty of attempted manslaughter by act, a lesser included offense. Or D, the defendant is not guilty. Any objection?
Not from the defense.
Count 2, we, the jury, find as follows as to count 2. Check one box only, again in parentheses. A, the defendant is guilty of kidnapping as charged. B, the defendant is guilty of false imprisonment, a lesser included offense. C, the defendant is not guilty. Any objection?
No objection.
No, sir.
Count 3, we, the jury, find as follows as to count 3, again in parentheses. Check one box only. A, defendant is guilty of burglary with battery as charged. B, the defendant is guilty of burglary, a lesser included offense. C, the defendant is not guilty. Special interrogatory. If you checked A above, you must make the following determination. In the course of committing the crime of burglary, did Frankie Bybee batter Marcia Soul? The 2 choices are yes, no. If you checked A or B above, you must make the following determination. In the course of committing the crime of burglary, was there another human being in the dwelling or structure at the time of entry? Yes or no? If you checked A or B above, you must make the following determination. In the course of committing the crime of burglary, was the structure Frankie Bybee entered a dwelling? Comments? If any.
No objection to.
All right. Count 4. We, the jury, find as follows as to count 4, again, in parentheses, check one box only, or check one only. A, the defendant is guilty of exploitation of an elderly person as charged. B, the defendant is guilty of grand theft, $20,000 or more but less than $100,000, a lesser included offense. C, the defendant is guilty of grand theft, $10,000 or more but less than $20,000, a lesser included offense. D, the defendant is guilty of grand theft, $5,000 or more but less than $10,000, a lesser included offense. E, the defendant is guilty of grand theft, $300 or more but less than $5,000, a lesser included offense. F, defendant is not guilty. Any objection?
No.
Count 5, we the jury find as follows as to count 5. A, the defendant is guilty of fraudulent use of personal identification information as charged for the 12-10-16 offense. Or B, defendant is not guilty.
No objection.
All right, state in each one of these you've laid out the specific date for the offense related to that particular charge. Is that correct?
Yes, sir.
All right, would you just take a couple of minutes, Mr. Kafir and Mr. Lake, and just go through counts 6, 7, 8, 9, 10, and just make sure we're all on the same page, whether there's any objections.
I cross-referenced the dates and they appear to be correct.
All right, very good, sir. Then we move to count, let's see, count.
You left off at 5.
Started at 5.
Yes, sir. And 6, 7, 8,
Aye.
9, 10, 11, 12, 13, 14 are all the same.
Are all the same.
Just with the dates, I have no objection to any of those and agree with the dates.
Very good, thank you. Count 15. We, the jury, find as follows as to count 15. Again, in parentheses, check one only. A, the defendant is guilty of offenses against computer users, in parentheses, defraud or obtain property, 12/22/2016, as charged. B, the defendant is guilty of offenses against computer users, a lesser included offense. Defendant is not guilty is option C.
One second.
Certainly.
Your Honor, my only pause is, certainly appears that it references the same thing twice.
It does.
I was just trying to distinguish what
Well,
distinguishes.
if you look at the jury instruction, when you're looking in the back of the book, or you look at the statute number, it is clear. Second-degree felony, which has been charged, includes defraud or obtain property. The lesser included offense does not charge defraud or obtain property. It merely says that you are using someone else's computer.
I understand the statute's clear. My only concern was, I don't believe the verdict form is clear, but that's.
Do you have any suggestions on how to make it clearer?
I don't.
I will make the comment that I'm looking at 12.6 now, offense against computer users as charged in Florida Statute 815.06, subsection 1, 2C, and it indicates that no lesser included offense has been identified for this offense.
Well, then I would ask that it be stricken.
It's 12.6.
Thank you. Well, in the jury instructions, it says lesser included offenses, category 1, offenses against computer users, and the distinction is defraud. So,
Can I see the book you're referring to? Just a question of the date, I guess.
the charge in the information is 815-06, 2A and 3B, second degree felony. And then, when you look at that,
Get the right one here. I'm sorry, is it under 2B?
it's in
All right, got it. It's 12.7 then.
this 4.7, sorry.
Okay.
And then it says, did so for the purpose of devising or executing a scheme for the drug, which makes it the second degree felony. The first degree felony, pardon, the
Lesser included is offense against computer.
Yes, and does not include that phrase about, devising or executing a scheme for fraud. So that's the distinction, and there is a lesser included.
Here it is
Is that a mandatory?
It is a mandatory category
Yes.
1 lesser included.
Category 1.
I mean, I have no say. Really.
It remains
Yes, sir.
in place.
It just looks.
Don't disagree, but
It is what it is. So,
so count 15 will have
15, 16, and 17 are all the same. I have no
15,
objection.
16, and 17 are all the same. The only change now is 18. And that reads, we, the jury, find as follows as to count 18, check 1 only. Defendant is guilty of fraudulent use of personal identification information, 12/13/2016 as charged. The defendant is not guilty as option B.
Yes, sir.
Any objection to the verdict form?
No, sir.
All right, very good. So the verdict form can be used tomorrow.
Thank you.
And as I said, I will be reading just that final jury instruction of submitting the case to the jury. All right, so Ms. Freilich, you will supply copies of the jury instructions, 6 additional copies of the jury instructions for tomorrow.
I shall.
All right. And any other matters that need to come to the court, be brought to the court's attention at this time? Yeah, we'll have to discharge them tomorrow as well. There was one juror last night that had a brick fall off a truck, smash into the front of his car, up into his windshield last night. So lucky we didn't lose one last night. So we'll keep all our alternates in place, just in case.